Welcome everyone to our LinkedIn Live. I'm Amanda Crosbie, Director and Head of our Business and Company team here at Roberts Crosbie Mortons and Lawyers. And I'm joined with my colleague Tony Peterson, who's Head of our Commercial Litigation team. Hamish Taylor was meant to join us, but unfortunately he's unwell. So thanks, Tony, for stepping in. And
Pleasure.
Tony will have some different insights because he comes from the litigious side. So it's good to have you on board. So today we're talking about what to consider if you're thinking about making an employee a shareholder, which is a common scenario that we see clients want help with, and a few people come through our door quite regularly. So we've just highlighted a few of the main questions that I find clients have most concern with or most interest in. And I guess just in general, when you're looking to make an employee a shareholder, typically clients do this when they're looking to retire. So as a sort of business succession plan, slowly get more and more partners on board to look at retiring in the future. But also retaining key people, particularly in their growth phase. So that's usually when we see clients looking to do this as a bit of a background.
Sure.
What's our first question, Tony?
So the first question we're going to address today is, like all good stories, we're going to start at the beginning. What are the first steps?
First steps. Well, I guess first steps are you need to think about what you personally want and what you want for your business. And I guess thinking about your future and the business's future is the paramount first step in my view.
Mm-hmm.
And in that sort of, you think about, are you looking to grow? Are you looking to succeed out of the business? Because that will depend on what you're looking to offer and what control you want to maintain, and potentially whether you want to offer shares as an investment if you're looking to succeed out of the business, or you might be looking to retain staff. So you're thinking, do I offer a small shareholdership but at a discounted rate or a lower rate? So all these questions you'd want to consider with the help of your accountant and your lawyer, just to give you some idea about, maintaining control and financial implications of a share sale to an employee. And then basically, when you've determined what you want to achieve out of this and what the structure might look like, then you need to obviously approach the employee and look at whether they're interested and in what terms they're interested, and also in what conditions you might want to put in place on that employee. So, for example, if you're looking at retaining or business succession planning to retirement, you're looking at wanting that employee to stay on board for a period of time. So that might be a condition of the sale, that they agree to, retain their employment, or they can't sell, or they can't exit for 4 years, for example, something like that. Just if the whole purpose is retaining the staff, then you want to sort of retain them.
Absolutely.
For some sort of period. And then I guess the next steps would be, once the employee is on board, engaging with your accountant and lawyer if you haven't already done so, to prepare some valuations if you depending on what terms you're selling, and also preparing some draft documents which typically would include your share sale agreement, a new employment contract, and a shareholders agreement.
Very good. A common question that I'm sure a lot of people will have when they're considering bringing on someone new to their business is, am I going to lose any control as a result of bringing someone on new? And what are some ways that you might manage that?
Good question, Tony. And I guess that's firstly about each individual business will be different depending on what you're looking to achieve out of this. So if you are looking for a retirement in the next couple of years, then you might look at losing some control to allow someone else to sort of step up and step in. If you're looking at retaining key staff and particularly growing, then you'd probably want to maintain control. And there's various ways you can do that. And if we talk about, we're bringing on someone as a shareholder, so we're talking about a company that the business is operating via. You've got directors and shareholder levels. So your directors basically manage day to day. And if you don't want to lose control, then you don't make the shareholder a director. So you maintain control of that day to day. If you did want to bring on someone as a director, then you look at implementing certain clauses in the shareholders agreement, providing that you're, say, the managing director or the controlling director, and dictating what decisions that you can just make off the bat and don't require any resolution of the board. But that can be discussed with your lawyer, and it's good to really go through and hash out exactly what you want to achieve, and then you can put that in the shareholders agreement. But bringing on a shareholder, they will have some equity, so it will dilute your equity, and that also dilutes your control somewhat. But it depends on the amount you're offering that shareholder, what really that would look like. So if it's only a 5% shareholding, then the minority shareholder really wouldn't have any control on voting rights, because you would always have a special resolution, which is 75%. And if you again, you would put in the shareholders agreement the decisions that would require special resolution, majority resolution. And the only other one is unanimous. So if you don't want any unanimous resolutions, you just don't put any of that in the shareholders agreement. But if you're looking at bringing on someone at more like 25%, then you need to think about, what sort of control they may have and what sort of control you would want them to have. I guess the more shares that someone has, then maybe the more control that you would be prepared to offer, given that they are growing and you might see them as an equal partner in the future. So basically it depends on the situation, and you can really dictate that and dig deep down when drafting the shareholders agreement. And Sophie Ammett sent through a few questions before this, and one of them goes towards this, and it's how can a business owner manage equity dilution when making an employee a shareholder, and strategies and structures to maintain control and balance interests. So I guess equity dilution is just part and parcel of offering an employee shares, unless you want to structure it by offering a specific or special class of shares that don't attract voting rights and only attract dividends. That will still decrease your equity though, because you're obviously
paying dividends.
But that would mean they have absolutely no control, because they've got a special class of share that has no voting rights. So that's another option. And I think we probably covered Sophie's question in that.
I think so. While we all hope that these types of things go well when you bring on a new shareholder, sometimes they don't. How do you manage exiting an underperforming shareholder employee? What are some steps that you could take to do that, and how would you manage that process?
Without sounding like a broken record, it's again about having proper agreements in place, and that's your shareholders agreement and your employment contract. So this is a big one that my clients are always concerned with, and particularly with minority shareholders as well. What if these people come on board and they're just not performing as an employee and not performing in the management role that you foreshadowed them in? Putting aside employment law, we're not going to cover that, but that's just dealt with in the normal course as an employee, and that's why you want your employment contracts with any KPIs and duties and everything like that really sound. But how you actually exit them as a shareholder is dealt with in the shareholders agreement. So how I like to do it is put in what I call trigger events. And basically that means if X occurs, you as the majority shareholder would have the option to buy the shares back off the exiting shareholder and force a sale. And X event might be their employment's terminated, or they leave their employment before the minimum 4-year commitment period that they've provided under the shareholders agreement. So they're sort of trigger events, and you can dictate within the shareholders agreement how the buyback will occur. And if they're bad trigger events, such as dismissal for misconduct or something like that, you might decide that they shouldn't be entitled to the equity growth in the shares that they've had, so you'll buy back the shares at the price that they paid. If it's I guess, a good trigger event. Good trigger events are more so, if an employee suffers permanent impairment, or after this minimum sort of 4-year commitment period, for example, they decide to go their own way, which is fair enough. They've given you 4 years of their time.
Yep.
You might say, well, you deserve to get that equity increase and that you'll buy back at market value. So there are various ways you can structure it, but again, it's depending on the matter, depending on your individual view of how you want to structure it. But that is all dealt with in the shareholders agreement, and we sort of provide advice to our clients on various options, and it's up to them how they actually want to proceed. But without the shareholders agreement, you can't force the sale of shares without, as you would know, going to court. Getting those shareholders agreements in place at the beginning is paramount to avoiding disputes. You can put certain KPIs and performance evaluations in the shareholders agreement.
Yep.
Because the shareholders agreement is not, I guess, governed by the employment laws. It's more of a contractual relationship. So, you can put in there, if you don't meet certain KPIs, that's a trigger event to force a sale, sort of thing. So, the sky's sort of the limit, subject to laws of oppression. And
that's right. Yeah. Something else that I've seen in some shareholders agreements is a sort of a probationary period for a new shareholder, where the majority shareholder might say, well, listen, I'm going to give you 12 months or 2 years, and if in that period I decide it's not working, then we'll basically undo the transaction, give you your money back, and I'll take my shares back, and everyone can go on their way. So that's something else that you can do to sort of maintain a little bit of control and give everyone an easy out if that comes up.
Yeah, that's right. And so the shareholders agreements are very important and
absolutely
worth spending the time and getting it right.
So let's say that we've now identified the employee in question who we would like to bring on as a shareholder, and we've had to think about, had an initial conversation with them, and they're eager. What information should we give to them to allow them to consider the process and take the next steps?
Good question, Tony. So I guess this is a commercial arrangement, really, and particularly if it's an investment. So if you're asking the employee to pay market value for these shares, that's an investment to them, that they really have a right to request whatever information they want from you to assess that investment and to assess whether they want to come on board. But there's no legal obligation for you to give them any of this information. It's a matter for you to determine what you think is appropriate to allow them to assess the investment potential, and potentially get their own business valuation or share valuation to determine whether the price they're offering you is the price they're willing to pay. So typically they would ask for profit and loss statements and other financial statements of the company to evaluate the current shares, but also, I guess, get an idea of how the business might perform in the future.
Yep.
Maybe ask if you've got business forecasting plans and things like that. That would be probably something that would typically be given. But just remember, when you're giving all this information, you're giving it to an employee at this point in time. They're not a shareholder and they haven't necessarily agreed to come on board. So you'd want to put some form of confidentiality agreement in place if your current employment contracts don't already cover that, because this is information that typically you wouldn't provide an employee. But it's a matter of what you're comfortable with, really, and what you think is appropriate for the employee to get access to work out whether they want to come on board and work with you in the future. So again, it's really a matter between the parties, what they agree, what the employee asks for, and what you agree to give them you think is appropriate.
Very good. And is there ever a need when you're bringing on a new shareholder or a new equity partner to change your business structure, are there tax consequences of doing that?
Well, what I've sort of spoken about to this point is I've assumed a company is involved, but if you don't have a company, then there probably is a need to amend your structure. So, for example, if you're a sole trader and you're looking to bring on board a partner, you would need to either form a partnership or incorporate. to offer shares. So there may well be a need to restructure just depending upon your current structure. There's also, complicated trust structures and things like that you might want to simplify and make it easier to bring on board a partner or, a minority shareholder. Definitely it's each case scenario type of thing. And you definitely should get advice from your accountant and your lawyer on that to set up, if you are restructuring, set it up properly, and whether that ends up being a company or a partnership or what have you. A company provides those two levels of control, a directorship and a shareholdership, whereas a partnership is just a partnership.
Yep.
So, it will depend what you're looking for, and what's going to be best for you. And regarding tax implications, when you do restructure, it is really a sale of the business to a different entity. So if you're a sole trader and you're looking to incorporate, you need to transfer that business to the new entity. A business is a capital asset. It will attract capital gains tax, and a very high level non-accountant advice.
Get some accounting
advice. But there are restructure rollover reliefs available, particularly for capital gains tax for small businesses. So definitely get your accountant's advice on whether you would qualify for that. But that would be a typical scenario when you're looking to restructure from a sole trader to a company, and you're a small business for the purpose of bringing on board a new partner. Then that might be a genuine restructure, and there is a CGT rollover relief available if your main purpose isn't to try and avoid tax. But yeah, definitely get an accountant's advice, but there may be a need to restructure, and there may also be available some CGT concessions to allow you to do that without having to pay capital gains tax on that.
And there's another question that came in from Sophie about some common pitfalls that we see. A large part of my practice is dealing with disputes arising between shareholders and directors and partners in businesses. And definitely the most common pitfall that we see is not documenting things at the start by way of a shareholders agreement or a partnership agreement. And then further down the line, people end up in a dispute, and it is so much harder to reach an agreement with someone when there's a bit of bad blood, emotions are running high, there might be some financial pressures that everyone is under. In my experience, it's so much easier to get a deal done and draft the shareholders agreement when everyone is excited about the future and hopeful for things that might happen. So getting these things done at the outset is the best insurance you can have, and not doing them is certainly the biggest pitfall that I see. I think that was all the questions that we had come in so far.
I think that's all the questions we had to answer today, and I don't think anything else has come in. So we'll wrap it up there, but there's good content on our website, particularly in relation to shareholders agreements, what they can and should include. And, our phones are open. We offer a free case evaluation. So if anyone has any other questions, feel free to reach out and visit our website for some further information. But thanks for joining us, and thanks, Tony, for stepping in.
Thank you.